Okay, so we're going to be going through basically what questions you should ask your Social Security disability hearing after your supplemental security income or Social Security disability insurance hearing. A lot of people, they have the phone call after the hearing, their attorney calls them and they don't know what to ask. These are the questions that you should be asking, okay? I always think it's weird when I call somebody after a hearing and then like they don't pick up, and I call them twice, they don't pick up, and then like 3 to 4 days later they call me back. They're like, "Yeah, I was just busy after the hearing." That's always been a weird experience for me. So like, post a federal hearing, if you didn't have the time to talk to your attorney 3 minutes after that hearing to go through like the wrap up, the sum up, the summary, like what the hell is so important? I mean, maybe they just needed an emotional break. That's always something. But there have literally been people who have done their hearing and gone back to work right after that. I've just been like, whoa. So here we go. Please remember to like. Please remember to subscribe. Don't be stingy with that like button. Let's get to it. First off, let's just get the question that everyone asks right out of the way. This is the one they always ask right after the hearing. How did I do? I always think this is interesting because it's not what is the likely outcome or what happens next. It's always how did I do? This to me shows that the claimant understands that the hearing is like live theater and that their ability to explain their impairments on the spot is incredibly important. Of course, we as attorneys, we go through the things that they did well with their testimony, the things that they did poorly with their testimony. If there's anything that really threw us off from running hearings with questions with them before, we go through that information at that point as well. Question number 2, people want to know what the likely outcome will be. You should ask the disability attorney, what's the likely outcome? Now, we have already done a video specifically on this topic, so you can kind of search through the prior videos. But a quick summary is that the disability attorney will take cues from the judge's actions and the hypothetical limitations imposed on the claimant's abilities to do work. So, right, if you do your disability hearing, right, the judge will ask hypothetical questions about jobs you could do in the potential economy. The vocational expert will give multiple jobs, usually 3 at a time. And then the judge will give examples of how that claimant, the hypothetical one, could be limited. And those limitations will specifically tell the attorney where the judge is at with the likely approval or denial. It'll also come from the judge's actual statements and or cues to the attorney. Cool. Question number 3. You should be asking what happens next. What happens next? 3 types of decisions, right? There's 3 types of main decisions: unfavorable, partially favorable, or fully favorable. The 3 flavors. Unfavorable, denial, probably to appeals counsel if there's, basically a reason that the judge made an error as to law or fact. Number 2 is a partially favorable. The judge wants to move and has moved your alleged onset date. Number 3, fully favorable. That means the judge is approving you from the date that you wanted as your alleged onset date. What happens next, right? So about 3 weeks later, you start getting your back pay. Once you receive that approval letter, about a month from that approval letter, you start getting your forward pay. Somewhere in there, usually around 2 to 3 weeks after the letter, you go ahead and begin signing up for all of your Medicaid, Medicare options available to you, and then you begin living your life. Okay, around 2 weeks into that, you usually do a pre-effectuation interview. All right, next question. 4th question you should be asking: is there anything you should be doing post-hearing in preparation for an open record, or if an appeals counsel filing should be required? Now, sometimes you do the hearing and the judge will say, I would really like to see some of this evidence, wink, wink to the attorney. And the attorney goes, yeah, cool, I got it. I'll go get it. I'll go get it. That's where the record stays open. You provide it to the judge, you get it in, you get it completed. Some judges really, really like to give the claimant the best shot that they can to go ahead and essentially have the best claim that they can for that hearing, even if they have to submit stuff after the hearing. Some judges, total opposite. The hearing was today. You had your shot today. This was the shot today. No post-hearing allowance. It's just the way it is. Some judges go one way. Some judges go the other way. Some judges have a 6% passage rate. Some have a percent passage rate in the 80s. That's why when people tell you, all you have to do is tell the truth and your medical evidence will speak for itself, that's total and complete BS. Most of you guys who have actually learned the system realize that very quickly. Those who basically have been found disabled way back in the day still live in that fairy tale land. But alas, that's the way it is. All right, next one. Oh no, let's stay on question 4. What you should be asking about, what you should be doing post-hearing. Post-hearing is always about preparation for potential appeals counsel appeal. Post-hearing is always about preparation for post-appeals counsel or appeals counsel appeal. What do I mean by that? After the hearing, the next potential appeal is appeals counsel, right? And as a result of that, when you want to go to this, next step up, right? You want to go ahead and make sure that you have everything lined up, or at least rolling in the right direction, or fixing the things that should have been fixed when your claim is going to go in front of AAJs, which are these appellate administrative judges, okay? Or administrative appellate judges. Now, as a result of that, you are saying, okay, cool, I've done my thing in front of the ALJ, the administrative law judge, the hearing judge, your little mini hearing / trial for disability benefits. And now how do I prepare myself for, you guessed it, appeals counsel, okay? All right, here we go. All right, next one is this. We're going to go over here. Okay, now, number 5. Well, I guess we could do a video on how to prepare for appeals. I'll do another video on that. Number 5, the 5th question you should be asking, okay? What could you have done more properly or done a better job at completing before the hearing? Now, a lot of claimants either fall into one of two camps with this. Camp 1 is that either they blame everything on the attorney or they blame everything on themselves, right? The extreme version of they blame everything on the attorney people, and I'll just tell you kind of how it works, is that the person who thinks, that they can blame everything on the attorney, like the extreme egotistical version of that person is that they believe they know everything about disability benefits. And they never get an attorney as a result of that because they believe they know the system backwards and forwards. There is literally an ocean's worth of Social Security disability law. There is, and mark my words on this, absolutely no single person on planet Earth that knows every current law or historic law of disability benefits. Regular folks watching this video don't even know what case law is and where to find it. Just to make sure I cleared that up for a lot of the people that are watching this, a chunk of the law that might become relevant to your claim is called case law. And it requires, for a lot of it, to be able to access it, a prescription to things like Westlaw or LexisNexis, to be able to actually access it, which means the almighty people who think that they know everything, they think that they know laws that they can't even physically access without paying for a specialty legal service. So, they don't get to have, even though they believe they do have it, the most recent rulings from the bench for disability-related hearings and non-disability related hearings that affect disability law. That's something that a lot of people don't know or don't understand. It's certainly nothing there's nothing about it on YouTube. There are literally hearings that occur, trials that occur, appeals that occur that don't have to do with disability to begin with. And then it ultimately ends up changing disability law because the case changes how we adjudicate claims or changes standards that the governments are required to have. And the weird thing is these know-it-alls, it's like they don't even, they believe they know it. I ran into one the other day. I was just like, and I literally said to the person, I said, look, I'm going to be as nice as I can with this. Obviously, you feel very strongly that you know how this stuff works. I've heard a lot of issues. I've heard a lot of things. And I said to the person, and it was probably not a nice thing for me to say, but I said, you to me are a case study individual. And the person got offended, of course. And I said to him, you have to understand, you are somebody who I would study as a case to figure out how it got to be this way. And the person was super offended. And I'm okay with that because now they're aware that somebody who does this for a living looks at them and says, how did this evolve to become that? Because to me, I want to know, how did this get to that? Anyways, we ended up having a really cool conversation at the end. But the point was, and I spent the time, I explained to them where things weren't going well, what they need to watch out for, stuff like that. And then they slowly started to evolve away from the, I know everything, everything's magical, and I'm a unicorn. Although by the very end of the conversation, we did kind of go back to them. They were becoming more unicorn again. So it's something where they can rev up. They can throttle that stuff back up. Let's see. Necronomicile. I feel like I know that name somehow. Sorry for being off topic. How do I know if I'm a bubble claim? I have agoraphobia, panic disorder, major depression, but because of this, I depend on other people for most activities. So that's too big of a question for this video. And I really appreciate the $10 donation. That's absolutely amazing. Can you call me during a live session? Tuesdays are Facebook, Thursdays are YouTube, usually around 8:30, 9-ish p.m. Tuesdays and Thursdays. You call the 407-279-1754 number. It's the main phone number for the law firm. Give me a call and we'll work on that. But the main things for that type of claim is that a bubble claimant will go ahead and not have essentially, so how do I explain this really quickly? Really quickly, bubble claimants live in a bubble. Everything going on in the world occurs around them, but doesn't really affect them. So they're never required to go out and do stuff. They're never required to go get a job. They're never required to go to certain medical. Like everybody will just financially cater to whatever their needs are. And when that occurs, no really good solid medical evidence is created. No really good solid attempt at vocational analysis or getting jobs and getting fired is created because they live in a bubble. And so as a result of that, those types of, impairments, agoraphobia, panic disorder, major depression, those are linked to a lot of individuals that are essentially in that bubble type of claim. And those claims are so incredibly difficult to win because, number one, the people taking care of the person in the bubble are defensive towards the bubble person so that the attorney can't advise the bubble person and get them to do the things that are needed to win a claim. And then the bubble person is so accustomed to being inside the bubble that they never really do any of the things that they're supposed to because they don't feel that they're necessary because they've just lived this way their whole life. So I guess the best way you can think of it like a bubble claimant is like a super catered to like doggy, right? A doggy that like lives in the house, never has to go outside to do anything, never has to have a function, never has to do like a work function. They're always catered to, lots of treats, lots of this, lots of that. So they never have to do any of the tough stuff that, a dog on a farm would have to do. And so the result of it, and that sounds kind of mean, but it's not meant to be mean. The result of it is that the person never has, they might have severely, extremely impaired impairments that limit them to being in this bubble situation to begin with, but none of the evidence that traditionally is created to win a claim is able to be created. So that's what happens with these bubble claims, is that it makes it so difficult for an attorney to modify the situation, interact with the claimant, interact with the parents to get that person to do what they're supposed to do. So we can always go through that. Good. It makes sense. Very good. With that said, continuing forward. Okay, then there's the second camp of people when it comes to this question. The question, just to rephrase, fifth question you should be asking is, what could have been done before the hearing? Then you have the next grouping of people who blame themselves. They blame themselves for everything that happens, not their attorneys. Sometimes, the attorneys should have done something that they didn't do, and the person is still blaming themselves, which I always think is weird. There's sometimes times where I didn't do something or could have done something, and they're blaming themselves. I'm like, no, that was on me. That was on me. I understand that there are a lot of shitty disability attorneys out there. I totally and completely get it. So when people say I hired one and then they never filed this or ran questions or did this motion or blah, 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 or did the thing that you were talking about in the video, I get it. I really do genuinely get it. There are claimants who have also on the other side of the spectrum insane expectations where they expect to talk to the attorney twice a week. Just to set the standards with that whole situation, you could potentially do that. You could have the attorney talking to you twice a week. But in that situation, you'd have to pay the attorney to have the staff and the attorney present like $25K for that same claim, not like $3 to $6-ish grand that they normally get paid. Because, remember, time equals money and work on something equals money. So when disability attorneys are making so little per claim, having twice a week contact with somebody like throughout the entire process is absolutely impossible. It's impossible. Okay, so here's the deal. I guess the bottom line is, when it comes to disability attorneys, there are some really, really good ones in the field. Use them while you can. But obviously, this field is not producing a lot of money at the moment. It may change with Congress, especially being so interested in what's happening with overpayments and the system in 9 years going to fail and bail situation. So this may change and disability, field may become like a cash cow again. It's not that. It was back in 2010. It stopped that in like 2013, 2014. Okay. So this second camp of people who blame themselves, they tend to be focusing on the wrong thing, which is worth, or rather self-worth. The goal is to post hearings to have clear bullet points of what needs to be completed to correct anything that should have been done before the hearing. Now, there are some claimants who purposely sabotage their claim. And, like some of these claimants, I'll call them 4 times before their hearing, and then they will text me literally the night before the hearing and say, oh, they were sick for the past 3 months, and now they're ready to go over hearing questions at literally like 11 p.m. at night before their like 10 a.m., hearing, which I had one of those this month. And I'm polite, but I'm pissed. I don't show them a lot of pissed, but I'm polite. but I'm pissed. Now, remember, claimants who have mental impairment spend a lot of time fretting about their big hearing day. This is because it defines their money situation. But, and this is something not talked about enough on YouTube, but also as equally important, it validates that hearing, being found disabled. It validates the disabled person that they personally believe that they are the disabled person that they claimed that they have been over all those months and all those years where basically their own family members had to pay for them not working. It takes them from feeling like a lazy, no good, can't do anything person and puts them into the category of, see, I was right. I am truly disabled. Okay. Understanding that their life existence as to how they are categorized in their own head and how other people in their close circle categorize them is just as important for some of them on the money part as the money part. So there you have it. The top 5 questions you should be asking your disability or SSI attorney after your disability hearing with the Social Security Administration. Please remember to like. Please remember to subscribe. Please remember to leave a review online if you can. Disability Resolution Law Firm or Disability Resolution Florida. We do have membership options, which makes it way easier for me to see your chat. On the side here, I can see Deb Carter's. I can see Nicolette Galindo. Let's see. Oh, I see a $2 donation right there. I'm going to give a little heart to that. Thank you. Thank you. I think you have a question. Yeah. So here's the thing. When you do the membership thing, I can see what you're typing. It's not just... they bold it a little bit. They put a color behind it. They color the actual type. It's a whole thing. So, all right. Do you think a cardiac with lumbar decompression, scoliosis, severe spinal stenosis, lumbar radiculopathy, bilateral knee replacement needed 2 more back surgeries could win SSDI on initial app? Yeah, it's possible. It's possible, but they're going to be looking at a lot of the 1.0 specifically for how many failed surgeries you had, and then limitations as to ambulatory devices. So get your walker with a cane, get your four-footed cane, get your walker with a seat, get your grab bars throughout your house. Make sure that you have a shower stool, shower chair. Build the claim. Make sure you have the basics. You can always call me during the live. We can always go through those details a little bit. All right, let's see if we've got anything else. Let's see. DJ said, I would like to be a case study. If anyone can learn from what I go through, would help it make it worth a while. And maybe we should do that at some point. Maybe I should case study particular individuals that give me the okay. Like they give me clients, I can't do that because, currently representing them, they have a hearing or they have, we're going through the adjudication process, the initial filing reconsideration, ALJ or appeals council level. Can't do it for them. But maybe there are people where I could do a case study and then I could share that with you and you can see what my thoughts are and what's interesting, what's good or bad. And remember, there's good and bad. Like you have to be open to the full breadth of the case study. So anyways, guys, I will catch you guys a little bit later. Let's see. We've got another one. Rob Ohio did something cool. He made something red there. I'm 100% PNT for OCD from the military. What are the issues vets are having for trying to get SSA awards you have seen? Well, first off, getting a PNT for OCD from the military is a good thing. 100% PNT. You're still, I don't know where you're at with your TDIU, but bottom line is OCD, you're going to check out your 12.0s. Look around more the 12.04-ish. Look at also the 12.06-ish for your depression, 12.08-ish, 12.15-ish. See if there's any applicable applications for the listing level criteria. Also realize that a lot of the military medical documentation is not detailed in the way and fashion that traditional private medication facilities. So we're talking about hospitals, clinics, doctors, specialists, postdoctorates that are outside of the VA's medical treatment. The VA does not usually put in the terminology that we're looking for in SSA land. So, realize that. Look, it's a claim I can always take a look at, but the bottom line is a lot of vets are getting denied left and right. People claim that the judges don't want to give them a secondary benefit. I don't think it's that. I think there's a few judges that are like that I've come across. I don't really think it's that en masse. It's just the vets, not to generalize, but the vets have a tendency to be really good at completing bullet points, but they have no person giving them a direction of what they need to beat or complete on this mission of getting disability benefits. And as a result of that, they're just kind of spinning wheels all over the place. And there's mud and dirt and gravel thrown up all over the place. Like I get some of those vet claims. I'm like, how did you mess it up this bad? And then I realized they were trying. They were just trying and they didn't know what to do. So I always like vet claims because vets, you can give a mission to them and they will get that mission done. You give them the hammer, you put out the nails, they'll get them all down, which is what I always love the vet claims, because you can give them literally a mission of what they need to accomplish and they'll do it. You know, a lot of other people, you give them a mission of what they need to accomplish, you get back to it, and one of the nails somehow got pulled out and they're studying it, and then they left it in the corner for 15 days because, you know, they were wondering if somehow it was going to change. It's a nail, you know. So anyways, Paul Harrison, thank you for the $5 donation. Super duper really appreciate it. Let's see, Nicolette Galindo, exactly, nurse for the VA here. Nurses have a huge advantage when applying for disability benefits, because especially when you team them up with an attorney that can talk to them, huge advantage. Like, so nurses understand basic fundamentals of the diagnostic impressions that are created in the environment. Number two, they understand basically what the severity levels are. You know, if somebody's just mild, they do this stuff, moderate this stuff, severe this stuff, and this, you know, for the extreme. Then they also know what are the transitionals and what, you know, so like, you know, this impairment usually transitions into this, or this impairment usually includes these other impairments. So they understand the bigger totality of the circumstances of the medical conditions. And there's a bunch of other things that nurses, and the other cool thing with nurses is that you can literally go through medical documentation and they know what you're talking about. So there's just a huge advantage when you have nurse clients, because you can really go through all the stuff with them. Paul Harrison, again, thank you for $5 donation. Excellent, Rob from Ohio. I will catch you guys a little bit later. You have a wonderful, wonderful day. Please remember to like, subscribe, and leave a review if you want to. I love waking up to those 5-star reviews for the law firm Disability Resolution Florida. And then we will catch up a little bit down the line. Please have a happy holiday season, whether it's Christmas, Hanukkah, whether it's any one of those. Enjoy. I will catch you later. And don't let your dog eat the trees on the ornament. I will catch you, or the ornaments on the trees. Thanks so much. All right. Bye-bye, everybody. Happy holidays. Bye-bye.